Good afternoon.
Good afternoon, Madam Chair and members. I bring to you Assembly Bill 2219, which I will note has gotten here unanimously out of the Assembly, and I think we're on a roll. I look to keep it going. Briefly, what 2219 does is the following. Under current law, there's no prohibition on the Attorney General disclosing donor information for 501c3 charitable, educational, and scientific organizations. Nevertheless, under federal law, the information is confidential. The information must be collected pursuant to the California Charitable Trust registration requirements. And what the bill does is essentially conform us to federal law. It prohibits the Attorney General from publicly disclosing the schedule of donors of these 501c3 corporations. It conforms state law to federal law and helps ensure confidentiality of the private information. One of the things, importantly, it does not do is change the underlying disclosure requirements. The charitable organizations still must provide to the Attorney General's office the information that is currently called for under the Trust Registration Act, but what we're doing is trying to keep that information confidential. This is, to be honest, a bill that might be in search of a problem, a solution in search of a problem, because the Department of Justice's own rulemaking process has already kicked in, and the department is looking at rules that are substantially similar to what's in this bill already. The question is whether or not the department will continue and in fact promulgate those rules, what they will look like, and whether we as a legislature think they are sufficient. And I highlight that because I want to make sure everybody recognizes that, number one, we're not trying to do anything with respect to disclosure or transparency, that these are rules that, as I say, got here unanimously out of the Assembly and are also being considered actively and will probably be adopted by the Department of Justice. The bill simply says, in essence, if those rules don't get promulgated by the Department of Justice, we in the legislature will adopt them ourselves. Which brings me to the suggested amendments that come out of the committee analysis. And Madam Chair, I want to thank you and the committee for the meeting that you and I have had and the opportunity to work this through. There is one provision in the proposed regulations by the Department of Justice that is not mirrored in the bill, and that has to do with disclosure under circumstances when it would be in response to a subpoena, other legitimate government inquiry, and I am happy to conform this bill to that regulation. I think that makes all the sense in the world. The other issue, of course, is if the department, in fact, imposes these rules or regulations or something substantially similar to them, I'm the first to admit this bill need not exist. And so I would certainly be willing to take the amendment that says it is conditioned only upon the failure of the department to enact these regulations or substantially similar regulations, because I recognize, as well as any of us do, that in the event regulations are required, it would be easier after they've been implemented for a while to work through any bugs through the regulatory process rather than come back through legislation. That said, however, the department may not complete the regulatory process, and most folks, to my knowledge, that have looked at this have said we ought conform with federal law and protect confidentiality of the donors. So with that, I urge and I vote, and I'm happy to take any questions.
Any witnesses in support? Any witnesses in opposition?
This bill's so good, we don't need no.
Well, let me tell you, I thought so at first, and we had a nice conversation, and I appreciated it. Then I started looking at some of these 501c3s. And what this bill, as I understand it, would do is put into statute the Attorney General's practice of shielding from public scrutiny information about significant donors to 501c3 charities. But there's a real question that 501c3 charities also make contributions. And I'm concerned we haven't been able to have a robust discussion in the state as to whether this information should be kept from public view as it is by the federal government. And we always, we don't always agree with what the federal government does. And for some of us, the disagreements can be attenuated by, whether or not we see things on a particularly ideological basis, or whether we agree with what the federal government does. But in most instances where we're not preempted, we do have the right to go in a different direction. So it seems to me that we really haven't had the conversation as to whether we want to go along with what the federal government is, or whether there should be some level of transparency concerning who funds these charitable organizations and where their dollars go. The fact that they are kept in isolation and they are kept away from public scrutiny in some instances, I think, is probably a good thing. But we haven't had the conversation. And I know that as I try to analyze the public attitudes and the attitudes of people in California, most Americans are pretty deeply concerned over the influence of money in politics. And this year's, I think, presidential election has spoken pretty loudly to that on both sides. And I think we really need to pause and have a deeper conversation about whether this is the right path to assure that confidentiality, that privacy, that secrecy, or whether or not we should have greater transparency in this area, whether we should do that before we decide to permanently and put into statute shielding donor information from public scrutiny. And there's a question. We have these different groups, and again, this is not a partisan issue. This is a problem on both sides with significant donors making donations to different groups. And we can't find out who those people are because they come under the protection of some of these secrecy laws and confidentiality laws. And I think that we really need to have that conversation before we put into statute and support shielding the information from public view. And I think it's an important conversation. I appreciate that if the conversation is had and there's determined to be a greater benefit to keeping this information confidential and shielding these donors, so be it, and that would be, in my view, an appropriate way to proceed. But until we've had that conversation, because I think the American people and I think the people of California are demanding greater transparency. Who is supporting these different efforts that are coming out and finding, creating names and sort of entities that you can't really identify who's supporting them, who is the money behind a particular group. I just think that by sort of putting this in statute at this point, we've really taken a step beyond having the discussion on that very important issue. So we had the conversation. It really got me thinking. My staff kind of reported to you those concerns. I still have them. I have them deeply because I think we have a problem as the money flows so like water in politics. The question I think the public has a right to know is who is funding all of these efforts? And if until we change Citizens United and until we change some of those rules, there will be this influx of money. I think the public and in our democracy, people have a right to know where that money's coming from. So with that, well, I would certainly appreciate your comment, but that's kind of where I'm leaning.
I appreciate where you're coming from, and I do want to say that I think that by raising, for example, Citizens United and raising some of the political issues that you do, you do strike a nerve with respect to the public, one that all of us, I think, ought be sensitive to if we're not already. However, those are not the types of political organizations that we're talking about here. They are 501c3 corporations. They've existed under the law and had protections precisely because they are not allowed to participate in the types of politics and, in fact, in some of the dark manipulations that have so I think, rightly incensed the public. So we're talking apples and oranges. We're trying to protect here organizations, for example, just today in this building, there are a number of folks wandering around meeting legislators with purple sashes on, and they're representing the Alzheimer's Association, which is a 501c3 corporation. We're trying to shield their donors, the financial information from their donors, being disclosed, which is a debate that's been had already for years in this country, and the decision had always been, especially at the federal level, to protect the confidentiality of those donors, to protect the financial interests and information of those donors, so that things like Social Security numbers don't get out, so that things like net worth doesn't get out, so that things that might discourage somebody from doing the sorts of good that they can do don't get out. That's what the bill, that's what the Department of Justice is looking to preserve, not to facilitate the dark movement of money. Those entities simply don't fall under this bill. Never would, don't intend to, are not 501c3 corporations. I think that's a distinction very much worth considering, and why the bill, despite those very legitimate concerns, the bill itself is going in the right direction.
I wish I agreed with you, but here's what I would suggest, that you mentioned that this bill may be in search of an issue. And I would like to have that conversation, because I'm not so sure there really is as clear a line as we would like or as we want between charities and political organizations. There are some, you mentioned Alzheimer's, an outstanding organization. They do terrific work. I'm a big supporter, and I suspect most of us in this room are, if not all of us. But there are not all charities are the Alzheimer's Association. And so there is some question, I believe, that we really should have that discussion. And maybe the distinction could follow thereafter, once we can sort of identify and perhaps get those assurances. Because I'm with you. If this is these are marvelous organizations, they should be allowed to continue doing the great work they are. And in those situations, the shielding of donors makes sense. But I'm not convinced that all of these so-called 501c3 charities are truly the charities that do that work. And so I wouldn't say that this is necessarily premature, but I just don't see where it is critical at this point that we step into that void, because I really think we need that discussion.
Well, I would say this is the vehicle to provide that discussion. If it dies in this committee, that discussion doesn't get had. And so I would urge that it continue moving along, at least until we've had an opportunity to have that discussion. If at some point the Department of Justice falls through in what looks to be its plan right now to pass these regulations, then we can revisit the bill. If the department moves forward with its regulations, then the discussion is had in the context of those regulations. But at this point, if the bill dies, the conversation doesn't happen, and I don't disagree at all that it should happen, and that there are organizations that are abusive of the 501c3 tax designation, and they should be exposed.
And of course, that could be on either side. What you and I are talking about now is the reason that we give protections to these charities. Although it's a good argument, spoken like a true lawyer, I think that we can still have that discussion. The Attorney General's office actually should have it because, in my opinion, because they've just made certain assumptions throughout time that I don't think are necessarily accurate in today's world, and I think for those reasons, I just can't support this. Again, I don't know if it's a cynic in me, but I do know that in today's world, people are really unhappy and are making assumptions about the kinds of decision-making and the immunity and the protections that they feel, rightly or wrongly, are being given to those who have enormous resources and are putting them into the political process, which many of us think has weighed the process against the people. And that, I think, that's where democracy gets threatened, and we see some of the kinds of knee-jerk reactions that we see in today's political world.
If I may follow up real quickly, and then I know Senator Morlock has a question. If the Department of Justice is the only one considering regulations. If this bill doesn't move forward, then that discussion that you suggest need happen arguably happens without us. It happens internally in the department's own halls as it's deciding how to make its rules and regulations. If we at least have this out there, then we are participants in that conversation. And for that reason, I would argue it would be premature, though the bill itself might be premature depending on what the department does. Killing it today is even more premature if, in fact, the legislature is to be involved in that discussion. Thank you, Madam Chair.
Thank you. Thank you very much. Senator Morlock.
Thank you, Madam Chair. I am not a lawyer, so I don't want to get into the legalese of it all, but I did spend 18 years preparing 990s in my practice days and was sort of my specialty. So I'm sure the forms have changed a little bit since then, but you don't really have to give donor names and amounts unless they're significant. I think it's 2% and 20%. Mm-hmm. So how would the Attorney General get any of that information? Because you file the Form 109, which is the state version, with the Franchise Tax Board. So I'm wondering if we're arguing about something that doesn't even need to be debated.
The information is out there, at least at certain levels, as you recognize, Senator, and it's required to be collected under the California Charitable Trust Registration Act, which might be the act under which those forms are promulgated. As the CPA, you would know about those particular regulations. It is true that there are thresholds, just like there are with political donations as well. So we are only talking, by definition, about the information that already, number one, has to be collected. Number two, is protected under the federal law as well. So it's that level of information. We're probably not, quite frankly, talking about the $10 and $20 donations and stuff like that. We
talk about significant donors.
Big money.
And we usually attach them at the back of the 990, and then we actually put confidential because you want to protect the donors. It's personal information. You don't want them to be solicited, et cetera, et cetera. So I think when we're ready to have a quorum again, I'm more than happy to move the bill.
Well, thank you.
We aren't talking about the $20 donor, however, but certainly
Not.
the larger donors.
Very de minimis amount of people that would be attached to the 990.
Although the amounts may not be de minimis. That's the issue.
Well, then you're finding out whether it's a private foundation or something, or the charity or the nonprofit is doing something different than what it's supposed to be doing.
Right. Okay. Any other questions, comments? All right. So we do have a motion. I'll take as your close. We've had the discussion.
We've had the discussion. I appreciate it. Thank you.
And I assume you're asking for an aye vote.
Absolutely.
Thank you
Please,
very
let's
much.
keep
All right.
the
Please,
discussion going.
please call the roll.
The motion is due pass as amended to Senate Appropriations. Jackson?
No.
Jackson, no. Morlock? Morlock, aye. Anderson? Hertzberg? Leno? Monning? Wajkowski?
No.
Wajkowski, no.
You have one vote, and thank you for your presentation.
Thank you all.
File item 17, AB 2362, Assemblymember Chu. Good afternoon.
Good afternoon. Thank you, Madam Chair and the Senators. Assembly Bill 2362 would require a homeowner association to provide notification to owners and tenants in a common interest development if the association apply pesticide without a licensed pest control operator. Last year, the legislature approved and the governor signed into law Senate Bill 328, which added guidelines that landlords and property owners must properly notify their tenant if pesticides are applied by a non-licensed individual. Due to the unique way they were regulated under the state law, Common Interest Development and Homeowners Association would not included in SB 328. So AB 2362s seek to close this gap and ensure that all tenants in property in California are protected from potentially harmful pesticide use via a proper notification. This bill has no opposition, and I respectfully ask for your aye vote.
Do you have any witnesses in support?
Yeah, good afternoon. My name is Brandon Kitagawa. I'm with the Regional Asthma Management and Prevention. We focus on trying to reduce the burden of asthma in communities most affected by the disease, and have been working with partners across the state on issues related to housing and health for the last few years. And as the Assembly member mentioned, this bill is a follow-up to Senator Hueso's SB 328 that came through this committee last year. Last year, we found out late in the process that the provisions of that bill did not apply in the context of homeowners associations because of the unique way they're governed in state law. And so this year's bill is intended to sort of mirror last year's effort so that the same notification provisions are required within the context of homeowners associations.
Move the bill.
Thanks.
Thank you very much. Any other witnesses in support? Very good. Any witnesses in opposition? Any questions from the dais? I think you've got a good measure here that I think you've taken all the amendments going forward, and unless there are any other questions, Senator Hertzberg, did you have anything for Assembly Member Chu on item 23? Entertain a motion. Is there a motion to move the bill?
No, Hertzberg.
Oh, I'm sorry. Senator Hertzberg moves the bill. Please call the roll.
The motion is due pass to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wykowski? Wykowski, aye.
Which one did we just hear?
17?
We have 4 votes, and we'll hold the roll open for the absent members. Thank you. And file item 15, Assembly Member Burke, if you'd like to proceed. We do try to go in file item order. So you are next up. This is AB 2337, Employment Protections. Good afternoon.
Good afternoon. Thank you, Madam Chair and Senators. According to California Partnership to End Domestic Violence, approximately 40% of women experience some form of physical, intimate partner violence. Such abuse causes trauma to the victim that negatively impacts their ability to live independently, parent, and maintain employment. Nationwide, women lose nearly 8 million days of paid work because of violence inflicted by their partner. This is the equivalent of over 32,000 full-time jobs each year. Thanks to Madam Chair's leadership in 2013, the legislature voted to ensure that when employees disclose that they are victims of domestic violence to their employers, that they are protected from discrimination and retaliation. Additionally, these protections came with a guarantee to reasonably accommodate to maintain employment. Today, too many people are still unaware that they have this guaranteed right. AB 2337 requires employers to inform their employees in writing of their rights guaranteed under existing law. There are victims in our state who quit their jobs, become further entrenched in abusive relationships, and become homeless, in part because they feel disclosing their abuse to employers is an additional burden. We must continue to do our part to empower vulnerable survivors in the workplace. I have a witness here in support from California Partnership to End Domestic Violence. I respectfully request your aye vote.
Thank you. Good afternoon.
Good afternoon, Madam Chair and members of the committee. Thank you for having me here. My name is Krista Nimzik. I'm with the California Partnership to End Domestic Violence. We were pleased to co-sponsor SB 400 a few years ago on this topic and are pleased to be here in support of AB 2337. As you all know, California has strong protections for survivors of domestic violence, sexual assault in the workplace. But one of the most important things we can do is make sure that all employees know that they have these protections and have these rights under California law. And making sure that these are provided through notice and posting will help survivors utilize those protections when they do need them. Making sure that they are aware gives them the opportunity opportunity to come forward, work with their employer, and come up with solutions in the workplace, whether those are reasonable accommodations or job-protected time off, to make sure that they get the help and support that they need while being able to maintain productive and stable employment. So we are pleased to support this bill and respectfully ask for an aye vote.
Very much. Are there any other witnesses in support? Any witnesses in support? Any witnesses in opposition? No witnesses in opposition. Well, I, of course, have to thank you for bringing this bill, because this is an area that I've been working on for quite a long time, and this is a bill that's a very logical extension of that work, and I clearly recognize and appreciate it. And if there were any amendments, and there aren't any, I would love to co-author it, but I really do appreciate this work. This is important. You can have laws, but if you don't know that you have them, and both making sure that everybody knows, hopefully will help us in reducing the incidents so that sometime in the future we don't need laws like this. But certainly I do appreciate your effort and your good work on this. And with that, we have a motion. Anything further to say? Yes, Senator Morlock.
Just for clarity, for my benefit, this is the word that's being used is requires. So I'm just kind of curious, because this is a mandate for employers. Is this the only way to get a good message like this out?
We worked with a lot of the groups to figure out what the best way was to notify. What we felt like was this was a way that we could protect both employers and the victims. By actually providing a notification, this protects both parties. So this was what we all worked on and found that this was going to be the best solution.
Thank you.
All right, we have a motion. The motion is to pass to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wachowski? Aye. Wachowski, aye.
Bill has 4 votes. We will hold the roll open. Thank you very much for bringing the bill.